Hi and good afternoon, everybody. Thank you for joining us for this webinar in relation to Labour's new Employment Rights Bill and hopefully covering some of the key points that employers need to know all about it. In terms of who will be presenting today, you'll be hearing from myself, from James Pike. I'm a partner in the employment team in Manchester, and I'm joined by Matthew Lewis, who is a partner in our team in Leeds. So before we get started, the mandatory few housekeeping points. So throughout the webinar, participants are going to be in listen-only mode. However, if you do wish to submit any questions, you can do so by using the Q&A function and selecting all panelists from the drop-down lists. We have got a lot to get through today, as you might appreciate, but we will do our best to answer some of the questions at the end of the presentation. We will also be circulating a copy of the slides and a link to the recording after the webinar. So, it's time for change was Labour's message in the run-up to the election, and then action, not words, was the message after it. So now the Labour Party is in power. Ultimately, what might this change mean for UK employers? Well, quite a lot by the look of the Employment Rights Bill that was published last Thursday. It was described as being a pro-worker, pro-business plan. And most of the employment reforms that have been outlined in this bill won't come as a surprise. They largely mirror previous announcements that Labour had made, both in the run-up to the election and before. But there are some fairly significant changes in here. Also, the way in which the government is proposing to implement some of the changes will inevitably make things much more complicated for employers. And I have to say, it really isn't clear which part of the bill is the pro-business part. So the aim of today's session is going to be to discuss just what's in the bill and some of the potential implications for employers. Now, alongside the bill, the government has published a next steps to make work pay document, which is effectively outlining its vision and long-term plans. And we're going to discuss what further changes have been promised towards the end of this session. I mean, the good news, if there is any, is that according to the next steps document, most of the changes in the bill won't come into force until 2026 at the earliest. And with the proposed reforms of unfair dismissal not being introduced before autumn 2026. So we do at least have a decent period of time for businesses to prepare. And I think that was one of the big concerns that many clients we spoke to had, is that the threat of this 100-day new set of legislation, everyone was expecting something very imminent and concerned they might have to react very quickly to them. So at least we do have some time to prepare. Employers are also going to have the ability to share their views on the reforms outlined in the bill as part of a consultation exercise. It's suggested that's going to start in 2025. So in theory, if there's going to be consultation, and of course, I'm sure Labour would like to say that all consultation will be meaningful, there's going to be some scope for the proposals to change. But I would suspect that really any significant changes are unlikely, given the stance that Labour have taken to date, and the level of discussions has already been had with businesses around these. I mean, I think what you can see from some of the changes, particularly unfair dismissal ones that Matthew's going to discuss in a second, is that Labour have been keen to try and keep to key manifesto promises, even if that means introducing some new, quite complicated legislation. So I'm not sure we're going to get big changes, but there's some hope that the consultation will at least take some of the rough edges off some of the drafting. And if you've taken a look at the proposals for 0 hours contracts and 0 hours workers, then you'll know what we're talking about. One of the key things to note is that these proposals relate to England, Wales and Scotland only. Employment law is a devolved power in Northern Ireland, so the Northern Irish are saved from a lot of this complexity. So that's what we're going to be looking at today, and I'm going to hand over to Matthew to take us through the changes proposed around unfair dismissal.
Thanks, James. I mean, someone has asked the question, which is how do we get involved in the consultation process? And I'll just pick up with that now, is that we will be doing a series of blogs, and obviously as the consultation processes are opened, we'll be emailing all of our clients and contacts so that they can engage in that. And we may well be holding kind of roundtables, panel discussions, so that we can actually feed in on a generic basis. So there are kind of three, I suppose, biggies so far as the changes in the bill are concerned. One is day one unfair dismissal rights. The second one is hire and fire, or dismissal and re-engagement. And the third one is around the collective consultation, and James will pick up on the collective consultation piece. So the first one, day one unfair dismissal rights. I think probably most employers are fairly happy with the 2-year process we have at the moment, meaning someone has to have 2 years before they can claim unfair dismissal, subject to there being a whistleblowing claim or a discrimination element. But I also think that most employers would also accept that you don't need 2 years to assess whether an employee is a good employee or a bad employee. And it probably has led, and Labour are very concerned about this, to kind of for some slack practices in that respect. So effectively, what's going to happen is that the bill abolishes the 2-year qualifying period set out in the Employment Rights Act. And so on the face of it, it becomes an unfair dismissal from day one. So it's a day one right, which actually fits neatly into the Labour's election pledge. But they've had to kind of reverse engineer the whole process in order to keep the trade unions happy and also to keep businesses happy. So effectively what's going to happen is the bill will give employers greater flexibility to dismiss employees during what they call the initial period of employment, which is likely to be 9 months. That's what the government are saying at this point in time. And that will be by way of modifying the test for unfair dismissal for dismissals that take place during this initial period of employment. There is also a so-called statutory probation period. Now, interestingly, that's what's referred to in the next steps document that James mentioned, but the bill itself doesn't make any reference to this term. So it's all a little bit confusing in that respect. The test would also apply to any dismissals that take place not just during the initial period, but where the employer gives notice during that period of time within 3 months of the initial period. So effectively, it may be for the whole of that first year of employment that someone wouldn't necessarily have unfair dismissal rights, which seems to go back to the place we were in before the Conservative government, when we had a 1-year unfair dismissal rights regime. However, the wording, nothing is as simple as it may seem. The wording of the bill modifies the unfair dismissal test, as I mentioned, so that where the reason for the dismissal during that initial period or the extension of it is for conduct, capability, illegality, or some other substantial reason relating to the employee. Now, just note that SOSR test has slightly changed in the wording, but apparently we'll get more details when the regulations come out. So that in those circumstances, there would not be a right to claim unfair dismissal. Interestingly, as it currently stands, it doesn't cover redundancy. So if you make someone redundant during that initial period, then they would have effectively unfair dismissal rights from day one. And the usual tests of fairness or unfairness will apply. So the potential issue here is that how does an employer have to justify it for the reason for dismissal? How do they have to justify it falls within conduct, capability, etc. So if an employee brings a claim to say it wasn't for one of those reasons, it was because you didn't like my shoes, or you didn't like the way I spoke, or you didn't like my jokes, working on the basis that didn't amount to sexual harassment, then effectively the tribunal can only make a decision after hearing all the evidence, and that's a real concern. For those at the moment, where we are at the moment with the 2-year threshold, you have to show whistleblowing or discrimination. Now, it seems to me that the scope is wider for potential challenge in relation to unfair dismissal. Helpfully, the bill makes it clear that employees who haven't yet started work will not be able to bring a claim for ordinary unfair dismissal. So you might wonder why that's the case, but it's to deal with a situation, for example, where you've recruited someone and then you decide actually before they set foot in the office, you don't want them anymore. And so in those circumstances, there won't be a pre-day one right. There is no day one right for those individuals. The exception will be if the reason for the dismissal is some sort of statutory right. So, for example, asserting there it was an automatic unfair dismissal. Again, helpfully, the right to claim unfair dismissal is only going to be open at this point in time to employees. The government had talked about giving this right to all workers, but that's not the case at this point in time. And as James mentioned before, we do have a period of time before this is likely to come into force. It won't come into force until autumn 2026. So until then, the current 2-year qualifying period will continue to apply. And I think that alleviates a lot of concerns that people thought this would be coming in if not kind of now, but certainly in spring 2025. So I suppose from the potential implications for people is that we've got a period of time now, but you're going to have a much shorter period of time once, say, you employ someone to make a decision whether that person is right or wrong. And it could impact on kind of businesses' hiring decisions. And I think when we had a panel discussion last week, and there was a real concern around that employers would not take a chance on people, for example, on hires and that might impact on social mobility or DEI initiatives, etc. And that can't be the intention. And employers have to resist that being the intention of the legislation. The government does acknowledge the businesses have got concerns about the impact of the change, and they also acknowledge the fact that the current tribunal system is creaking. But the government has effectively said it'll come out in the wash. So the other point is that in the next steps document, the government has effectively said that they will consult on the compensation regime for unfair dismissal. So what they're suggesting is that successful claims during the statutory probation period probably won't give rise to a full award for compensation as we currently have it under the unfair dismissal process. So as far as next steps are concerned, there's going to be more focus on who you're recruiting, getting that right, because if you get it wrong, you've got a shorter period to make the decision, making sure you have probationary periods in place in your employment contracts, making sure that managers understand that they have to manage performance and they have to manage conduct in the workplace and they have to manage absence processes during those probation periods. So you might have a probation period of, say, for example, 3 months and then extend it for another 3 months. The government has suggested, so far as process is concerned, that it would consist of holding a meeting with the employee to explain to them why their performance is not up to scratch, and the employee would have the right to be accompanied by either a work colleague or a trade union representative. So they're suggesting it might be a light touch, but we are all concerned that we don't want to end up in a place where we're looking back and thinking, oh my God, we've got those kind of old school disciplinary dismissal procedures back in place. So hopefully it will be a light touch. Other things to think about, maybe as we get further down the line, think about, do you think that actually during your probationary period, you might have a shorter notice period, so that you're not on the hook for longer notice during that time? And also thinking about if you have enhanced benefits of employment, so for example, sick pay, company sick pay, holidays, etc., you may think about, are we going to introduce those after the employee has successfully completed their probation period? Just very much as an aside, because I think it's been a while since we've had something as short as a potential 9-month unfair dismissal period. If you look across other OECD countries, of the 38 countries, 37 have a right to protection against unfair dismissal, and in 36 of those, the qualifying period is shorter than our qualifying period of 2 years, and in 25 of those countries, the qualifying is 5 months or lower. So even if the government does come back with a 9-month qualifying period, maybe we should think ourselves at least a little bit fortunate, but maybe not as fortunate as we have been. So dismissal and re-engagement, or as everybody seems to be calling it, fire and rehire. So this is the only way really you can force a change with employees. So it's a process whereby if employees are unwilling to agree to propose changes to their terms and conditions, then as an employer, you go through your consultation process, you dismiss them, and you offer to re-engage them on the new terms and conditions. So that's the process. It's currently a potentially fair reason for dismissal, providing that the employer can demonstrate they have a good business reason for affecting that change. And obviously, there's been a huge amount of bad press about this, with P&O and others kind of effectively what's been seen as bullying employers, trying to force changes to reduce their overheads. But however, this is actually a last resort for a lot of employers. So for example, imagine you're running a factory, a food factory, and you have a shift pattern, and you need to change that shift pattern from, say, for example, an 8-hour shift pattern to rotating 4 on, 4 off. If employees do not agree to that, and you need to make that shift pattern in order to satisfy customer demand, the only way of making that change is to go through the dismissal and re-engagement route. The problem is that no one likes fire and rehire. The previous Conservative government introduced a new statutory code. It's kind of relatively short-lived, I suppose. It came into force in July this year. It didn't, as it were, outlaw the fire and rehire, but essentially set out the steps that an employer needs to go through in order to effect those changes. However, the bill, if implemented, will essentially outlaw dismissal and re-engagement. And dismissals will be unfair where the reason or the principal reason for that dismissal is that the employee didn't agree to the employer's requested variation to the change of terms and conditions set out. So effectively, there is no business case defense. And what the government is proposing to put in place is that they'll be automatically unfair unless the employer can show, and I'll read this out. It says the reason for the variation was to eliminate, prevent, or significantly reduce or significantly mitigate the effect of any financial difficulties which at the time of the dismissal were affecting or were likely in the immediate future to affect the employer's ability to carry on the business as a going concern or otherwise to carry on the activities constituting the business, and in all the circumstances the employer could not reasonably have avoided the need to make the variation. So in other words, unless you are in a distressed state, you're going to find it very difficult to justify any change to terms and conditions on this basis. The bill sets out the matters that the tribunal will consider in determining whether a dismissal is unfair or fair in these circumstances, although it may be largely immaterial if the employer can only make these changes if they're kind of on the brink, as it were. So the matters they'll consider are: have you consulted with your unions? If you're unionized, have you consulted with employee reps? And also, what incentive have you offered employees in return for agreeing to the variation that as an employer you're looking to put in place? It's difficult to see how an employer who is in a financially distressed situation can be offering a significant incentive to employees. But anyway, that's where it is. We really do hope that as we go through the consultation process, the government will take a step back from this. Because I mentioned it's usually a last resort for most reasonable employers. And the code, yes, that code could be strengthened, but outlawing fire and rehire effectively other than in a distressed state seems to be going, a few steps too far. Bearing in mind that on the flip side, industrial action is a last resort for a trade union where it's in dispute with it's the employer. And so actually removing this last resort for employers effectively makes everything very one-sided. And as James will talk about in a moment, in fact, industrial action is going to become that much easier. So what does that mean going forward? Well, if it stands, what it's going to do is going to give the whip hand to employees, employee reps, and the trade unions, because you're really going to have to look at what incentives you put in place in order to get a change through. The other potential outcome is that employers may look at redundancies and reducing their workforce instead of changing terms and conditions if they can't change terms and conditions because they're not in financial difficulty. There is also the prospect, and I say this with a word of caution, that you could try to put in flexibility clauses in your contracts of employment. However, these would need to be very precise in order to cover changes to terms and conditions. So a general clause which allows you flexibility to change terms and conditions when you want to on, say, for example, 12 weeks notice will not fly in this case. The other thing to note very briefly is that the next step document says that the government will also consult on lifting the statutory cap on protective awards. So if you're found not to have consulted properly on a collective basis where you're looking to make these changes, then obviously the cap may be lifted. And I'll leave that for James to pick up on the trade union issues.
Thanks, Matthew. So I'm going to cover off now the changes around collective redundancy consultation, which we think is another kind of biggie, for want of a better description, but one I don't think really has got all the attention it deserves. So just to kind of reflect on what the collective consultation obligations are when they kick in. So that obligation is triggered where an employer is proposing to dismiss as redundant 20 more employees at one establishment within a period of 90 days or less, and that's found in section 188 of Tulrucker. And what the government is saying it's going to go ahead with is essentially its proposal to extend the circumstance in which employers will be obliged to carry out collective consultation. And the way they're proposing to do that is within the bill, removing the words "at one establishment" from section 188 of Tulrucker, which effectively means that we're going to be back to the position which we were following the AT's decision in the wake of the Woolworths collapse in 2013. And people may remember that case, and there the AT held that actually collective consultation obligations would be triggered when 20 or more employees across a whole organisation are proposed for redundancy rather than 20 or more employees at one particular site or location. And it reached that decision in terms of considering compatibility with the Acquired Rights the directives in Europe. And although interestingly, that decision was appealed and actually overturned at European level. So we did revert back to the one establishment principle. But for anyone who remembers the couple of years after that decision, they'll know that dealing with redundancy exercise at the time was particularly complicated in terms of determining when and how you engaged in collective consultation. Because in essence, what this is going to mean is that employees are going to have to consult with appropriate representatives, which is what Tulrucker requires, whenever they're proposing to dismiss as redundant. And I should stop there to say redundant in these circumstances also includes dismissals that arise from a failure to agree changes to terms and conditions, albeit, as we've just heard from Matthew, those circumstances are likely to be few and far between going forward. But where you're proposing to dismiss as redundant 20 or more employees, across the business. Now, if you're a single site employer, you probably haven't got an awful lot to fear from this decision because it isn't really going to change your position. But multi-site employers, which I suspect many of you are, going to need to look again at how they deal with redundancies across their business, because this change is going to make things difficult, both legally and practically, and would mean that collective consultation is going to be triggered much more frequently than is currently the case. So it's going to be really important for there to be real detailed planning around these kind of redundancies, and in terms of communication at kind of a national and national level about what is happening. You'd need to ensure that all relevant proposed redundancy dismissals are identified and tracked. So if you've got managers at local level who may currently have the authority to make redundancies without reference to head office, you'd need to ensure they're alerting HR nationally of any proposed redundancies, so you could keep a running total of proposed dismissals to ensure that employees don't inadvertently breach their collective consultation obligations. I mean, for me, one of the real issues with this change is that it means employers are going to have to collectively consult in relation to proposed redundancies, which are entirely unrelated to one another, with totally different timescales at sites at different ends of the country. And you also may have to deal with the tricky issue of collective consultation obligations being triggered in relation to redundancy exercises which are already underway, or in some circumstances even concluded, but which had only been done on an individual consultation basis. And so it's these kind of practical issues that will need to be addressed. And it's one of the reasons why I have to say it's not entirely clear to me what wrong it is seeking to right in making this change. Whilst the government has pointed to in other areas, this is why we're doing this is why we think this change is important, I'm not really clear on why this collective consultation change is necessary. I mean, going forward, the only way to really kind of get round the duty to consult collectively will be to ensure that you don't trigger the obligation in the first place. So the duty is only triggered where you're proposing to dismiss 20 or more redundant in a 90-day period. So you'll need to stagger them, so you're making redundancies over a longer period. That's probably your only way of avoiding it. But obviously that's going to become much more difficult when you're dealing with different parts of the business, with different business cases for those changes, and parts of the business that may not normally speak to one another as well. So we'll have to wait and see exactly what happens. But it's certainly an area where we recommend that companies engage with any consultation exercise that takes place, just to make sure the government are aware of the potential implications of such a change. Particularly, as I say, it's one where I think there could be real difficulties on a practical level that I suspect the government just doesn't appreciate, as with so many of this. So I'm now going to talk a bit about the changes in the bill around trade unions. And as you would expect, given the trade unions have been the real kind of standard bearers for these changes and kind of the driver behind many of it, the bill does make a number of significant changes to trade union legislation, both in terms of repealing some of the changes that the previous Conservative government made, and also adding in a few other rights and protections for good measure. Now, we're conscious that not everyone in today's session will have a trade union presence in their business, so we're going to kind of stick to the headlines, and we will probably look to do a further session in due course, looking specifically at the trade union changes in more detail. But having said that, I think these changes have the potential to touch, lots of businesses that don't currently have trade union presence, because in essence, what Labour is seeking to do is give trade unions, who I have to say are freshly emboldened from now having Labour in power, now seeming to have more of a seat at the table at a government level, with its set of reforms coming in, Labour looking to make it easier for them to get recognition within the workplace. And I think we're already seeing across a number of clients kind of new approaches from unions about recognition. And I think that's something that's only going to continue. So just touching briefly on some of the key changes. The first is in relation to a right to statement of trade union rights. And in essence, this almost extends the Section 1 obligations employers have, because employers will be required to give workers a written statement that the worker has the right to join a trade union. And that statement is going to have to be given at the same time as the employer gives the worker their statement under Section 1 of the Employment Rights Act, so their statement of their main terms and condition of employment. So presumably this is something that will probably end up being provided in the worker's contract, and you're going to have a standard clause that deals with that. That's probably something which we can all live with. I think a change which is going to cause more concern and consternation is the rights of trade unions to access the workplace. And as I've already said, it's not only employers which currently have a trade union presence need to be aware of these changes, because this is one of the things that will affect everybody, or potentially affect everybody anyway. So the new bill gives trade union officials a new statutory right to access workplaces under what's called access agreements, which will be entered into between employers and the listed trade unions, which is basically there is a governmental list of all the actual official trade unions, and they have to be on that list. Now, under these agreements, the unions are going to have the right to meet, represent, recruit, or organise workers, whether or not they're members of a trade union, and to facilitate collective bargaining, so they can come in to meet people for all of these purposes. Now, these new rights won't cover organising industrial action, so there's a key distinction there. So how it's going to work, trade unions will ultimately have the right to request access to a workplace, and employers will then have a period of time within which to respond. And ultimately, if the parties can't agree in writing terms on which the trade union officials are to have access to the workplace, a reference can be made to the CAC, and it will make a determination on the issue, and it will do so in line with what are called the access principles. And this covers essentially the officials of the trade union should be able to access a workplace for any of the access purposes, which are the ones I've just discussed, in any manner that doesn't unreasonably interfere with the employer's business. And an employer will then should really take reasonable steps to facilitate the access of the trade union officials to the workplace, and it should only be refused where it's reasonable in all the circumstances to do so. So lots of the use of the word reasonable, that seems to me lots of potential for dispute and challenge, and both parties will have the right to make complaints to the CAC on the grounds that the parties have breached the agreement or haven't taken the appropriate steps to allow access. So really, what should we be doing about this? And I think particularly in light of this and another change I'm going to talk about in terms of how recognition is obtained, I think particularly employers who are in non-unionised workplaces, I think it's a good time to consider your current arrangements or practices in terms of how you engage with your employees to try and mitigate the risk of trade unions getting a foothold within the business. taking steps such as, instigating employee forums, listening groups, things that mean employees feel they have a voice in the business, can be really useful and helpful to avoid union recognition, because then employees are less likely to be interested in unions representing them if they think they've got a voice heard, and if they think that they get reasonable terms and condition, because ultimately it does tend to be things like pay that unions really jump on. So kind of briefly, in terms of some of the other changes, in terms of obtaining trade union recognition, as I said, Labour are trying to make that easier as well. So they're trying to simplify the process of statutory union recognition. As it stands, a trade union can apply to the CAC if they satisfy certain conditions, and that requires having at least 10% union membership within the proposed bargaining unit. And then they have evidence that the majority of the employees are in favour of recognition. And the bill's ultimately going to look to simplify that and make it easier and not have such high thresholds. And I have to say that and other changes, I have to say, give me a cause for concern, not just because we might get greater union recognition, but you might have union recognition in workplaces where there is not high union membership. And anyone who goes through things like pay bargaining will know that you run the risk that the minority hold the majority to ransom, because the union ultimately only are interested in speaking to their members and not everybody else. Other changes that we're going to see is, as I say, largely repealing a lot of what the Tories introduced in the Trade Union Act in 2016. So a lot of that's around industrial action ballots and the turnout and support threshold. So at the current state of affairs is that at least 50% of the people who are eligible to vote in the ballot must participate in order for it to give you a lawful result. And then 50% of those people must vote in favour. They're going to remove that turnout threshold, so it'll just be a simple majority of the people who participate. They're also going to reduce the notice requirements. So the Trade Union Act in 2016 increased the notice of industrial action to 14 days from 7, and then we're going to go back to 7 again. So we're seeing a lot of the changes that were previously introduced removed. We're seeing a strengthening of the trade unions' status and position. And so it seems likely that unions, where they are in the workforce, will feel like they have a much stronger hand to play. And it is something to be wary of if you don't currently have trade union recognition, but particularly if you do know you've got trade union members, to be mindful that they may come knocking, and just taking steps to potentially try and mitigate the risks around that.
I better come off mute. So just going to pick up on a couple of the questions. There is nothing in the bill regarding fixed term contracts. For collective consultation with regards to redundancies outside England, Scotland and Wales, TELRICA only applies to Great Britain, so that should give you some comfort in that respect. With regards to multiple legal entities, as it currently stands, the test is per legal entity, so that if you have multiple group companies and you're making redundancies in each of those group companies, they shouldn't be combined for the purposes of the proposed new legislation. And one of the ones was about even if you don't have a trade union, you still have to notify employees of their right to join a trade union. Yes, that will effectively become, as James said, a Section 1 statement requirement. Okay, so I'll rattle through some of these because they don't have, I suppose, to some extent, the big impact that the other issues we've spoken about. But the government, regarding flexible working, the government refers to the changes in the bill as making flexible working the default position. And I think that's a little bit misleading. So there's still going to be, workers will still be required to make a request, and you'll still be entitled to reject a request on the current, one of the current 8 business reasons. So for example, impact on employment, on performance, or you're unable to cover the workload. So so that won't change. However, what they're saying is, what the bill is saying is that they will amend the employer's duties in relation to flexible working requests to expressly provide that when you refuse a call request, it has to be for one of those 8 business reasons, and it is reasonable for them to refuse the application on that basis. So it introduces a new reasonableness test, as James has already mentioned. Lots of reasonable tests in all of this piece of legislation. But I don't know how much difference that will actually make. It may well be more of a process thing, but it's more about thinking, if I'm going to reject it, why am I rejecting it for this reason? Do I think that it is reasonable to reject it on that basis? So it's a bit more of a thought process. The good news at the moment is there's no change to the penalty for failing to comply with these provisions, so that will remain at 8 weeks pay. Dismissal during pregnancy or whilst on maternity leave. You'll recall that on the 6th of April this year, the additional protection from redundancy that was granted to those on maternity leave was extended to include pregnancy, starting from when the employee informs their employer they're pregnant and for 18 months after childbirth. So it doesn't mean you can't make them redundant, but what it does mean is the employee is entitled to be offered, as opposed to merely having the opportunity to apply for, an alternative role if there is a suitable alternative vacancy. And the bill as it stands is to introduce regulations granting women greater protection against dismissals during or after a protected period of pregnancy. And that won't only be just in redundancy scenarios. So it's going to widen that scope. And at the moment, we don't know what that scope is going to look like. And then there are a few tweaks to some of the family-friendly pieces of legislation to make them day one rights. So statutory paternity pay, no longer need 6 months continuous service to be eligible to take paternity leave. Statutory parental leave, no longer to have 1 year's service, so that will become a day one right to take unpaid parental leave. Interestingly, there is no reference to shared parental leave in the bill, so it seems that eligible employees will still be required to have at least 6 months service to take that leave. With regard to statutory bereavement leave, this will be changed to bereavement leave, but will give them a statutory bereavement leave to other employees to be set out in the regulations. So it'll be widen it from the current scope, where at the moment you have to be a parent who loses a child under the age of 18, or you suffer a stillbirth from 24 weeks of pregnancy. The intention is to widen that from just parents. What's also not clear at the moment is whether employers will have to satisfy the 26-week qualifying period of service, or whether this will be another day one right. And then just moving on. So I suppose we're all getting used to the new mandatory requirement to take reasonable steps to prevent sexual harassment in the workplace, coming into force on the 26th of October. The government has confirmed via the bill that it will be extending this obligation on employers from taking reasonable steps to prevent sexual harassment in the workplace to taking all reasonable steps, which actually could place a materially more onerous obligation on employers. And it means that actually the Equality and Human Rights Commission, who have only just amended their technical guidance, will need to amend it again. So for this extended duty, the government has indicated via the bill that it will introduce new regulations which will set out the steps that will be regarded as reasonable for these purposes. So that will include things like, undertaking a risk assessment, publishing your policies, taking appropriate steps relating to reporting and handling of sexual harassment steps. Our concern is that all is an extremely unforgiving and inflexible standard, and I just don't think that the proposed regulations will be that comprehensive in covering all. So it does mean that employers will be exposed. They're also going to reintroduce the protection from harassment by third parties, and I think in line with the new duty to prevent sexual harassment in the workplace, lots of employers are looking at their policies, and lots of policies for employers do say that they won't countenance any sexual harassment by a third party, whether that's a customer or a supplier, etc. And employees have the opportunity to raise a complaint about that. However, this is going to go that much further, and it will it'll cover all protected characteristics, not just sexual harassment, and it will make the employer liable where an employee is harassed in the course of their employment, and it's shown that the employer has failed to take reasonable steps to prevent that harassment by that third party. So this seems to be kind of a volte-face. We've seen it. It kept first. It was introduced in 2008 into the Sex Discrimination Act, and then it became part of the Equality Act. The provision was repealed by the last government as being kind of, I suppose, unnecessary and confusing. It was then going to be reintroduced in the autumn, but there was alongside that the kind of mandatory duty to prevent sexual harassment. But I think everybody thought it put it into a too difficult box. Particularly, there was a lot of debate around those people working in the hospitality sector, and if employees or workers overheard comments from customers which they found offensive, how does an employer deal with that? But it seems that the government is intent on reintroducing this. So that is a kind of watch this space. Workers who report sexual harassment will qualify for whistleblowing protection. It's those who, if they're subject to that, they see it, or they report it, they're protected from whistleblowing. Again, I don't think that's a significant piece of legislation that people should be quite concerned about. The bill also gives the government power to introduce new regulations obliging large employers, so those with over 250 or more, to develop and publish what they're calling equality action plans. So that is to show the steps that the employer is taking with regard to certain matters relating to gender equality. So that's how you're dealing with your gender pay gap reporting, as well as supporting employees who are going through the menopause. Interestingly, the government hasn't taken up this opportunity to add menopause as a protected characteristic under the Equality Act. And I don't know why that hasn't happened, but there was a lot of debate about whether that would happen or not.
Thanks, Matthew. So I've already mentioned the horrible provisions around 0 hours contract, and they really is some terribly drafted set of provisions. So we're not proposing to tackle them in detail today, partly because they're so complicated, it's almost impossible to understand them. But we just really want to give some highlights around this issue. And the first thing really to say is that despite what the government's press release might say, it is not banning 0 hours contracts. What it's doing is putting in place provisions that seek to guarantee that workers engaged on such contracts can get a certain number of hours of work based on what they usually work. And the bill really contains what can only be described as ridiculously convoluted wording that sets out the circumstances in which employers are going to be required to make what is called a guaranteed hours offer to any 0 hours worker, and those on low hours, which effectively offers them a guaranteed number of hours based on the number of hours that they've worked during a reference period. And the next steps document talks about 12-week reference period. And depending on the circumstances, the offer is going to have to take the form of a variation to the worker's existing terms and conditions, or an offer of a new contract. Now, the government has included low workers within this to ensure that employers can't avoid the measures by moving 0 hours workers onto a slightly higher number of guaranteed hours, which I think is what happened in quite a lot of instances, kind of in the wake of the first kind of debate around 0 hours contracts, when Ed Miliband got very excited about them in 2015. That lots of people were moved to kind of small guaranteed number of hours, but the government hasn't said what low hours will constitute, and that's going to form part of the consultation. And we're left with really complicated provisions dealing with, well, what happens if the worker's contract is terminated during the reference period? What if the offer is withdrawn? What happens where the worker works more hours in one period than another? So we're left with a really, really complicated set of provisions, which again feels like the government over-engineering and over-legislating around a particular issue that maybe wasn't as broken as they seem to be suggesting that it was. Eligible workers are going to be able to bring complaints to an employment tribunal if there's a failure to comply with these complicated provisions. It appears that there's going to be a statutory cap on the amount of compensation that can be awarded, so we'd expect it to be like a certain number of weeks' pay fixed at either at the statutory cap or otherwise. That's what there would be. Really, it looks like these provisions are there to try and dissuade employers from using 0 hours contracts. And almost part of the reason for why they're so complex, and I think this is at the heart of a lot of what these proposals are, is that the government is trying to anticipate, well, how might employers sidestep these obligations? So we're almost kind of legislating to avoid you being able to get around them. But the consequence of that is that we get left with really complicated legislation. The bill also deals with kind of what's talked as one-sided flexibility. So it's going to introduce new obligation on employers to give reasonable notice of shifts that they require a worker to work. And that's going to include notice of how many hours to be worked, the times, the days, and the case of 0 hours workers and certain other workers that are going to be specified within the regulations. They also will need reasonable notice of a cancellation or changes to a shift. And we're expecting that the regulations will give us more details about form and manner in which such notices have to be given. But it's going to give workers the right to be paid for certain shifts that are cancelled or moved or curtailed at short notice. I mean, in terms of the implications, ultimately these changes are going to increase the administrative burden on companies in terms of making sure it gives reasonable notice, it's keeping appropriate records and all of those things. There are also likely to be financial costs, particularly if having to compensate workers for cancelled shift. And ultimately, it's just going to mean employers will lose flexibility because it'll be much harder to offer work on short notice or to make changes to shifts where they have, spikes in demand. It's also worth noting that the Workers' Predictable Terms and Conditions Act 2023 will no longer be coming into force. That was a piece of legislation introduced by the previous government. I'm going to very quickly talk about pay. Anyone in the hospitality business will probably be aware of the changes that were brought in around tips and gratuities. That came into force on the 1st of October this year. And alongside an obligation to ensure that any kind of tips, gratuities, service charges actually were allocated to workers on a fair and transparent basis, employers will have to have a written policy in place setting out how it ensures that happens. And really what the new bill does here is introducing a new obligation on employers to consult before producing the first version of a written policy. So there's going to have to be engagement with staff around what that policy looks like. Other thing on pay to mention is around statutory sick pay. I think this is one that's been talked about quite a lot, that again, it's going to become a day one right to get SSP. The bill also removes the current 3-day waiting period for employees to get SSP, removes the lower earnings limit, so that everyone effectively will be entitled to it. So obviously these changes are likely to cost employers more because more workers will be able to claim SSP, especially in light of the current increase in sickness absence that we're seeing in the UK. And so that's something that that employers will have to deal with. Now, what the government hasn't suggested is it's going to significantly increase the amount of SSP that's payable. It's currently £116.75. I know that the unions in particular would like to see a more meaningful level of sick pay guaranteed under SSP regime, but there's currently no proposals to change that. And then kind of finally, the government is also saying they're going to bring in a single enforcement body called the Fair Work Agency. And this is a proposal that was first made as part of the Taylor Review of Modern Working Practices and had been floated but never actually introduced. And the idea really here is to have a single enforcement body that's going to have the ability to inspect workplaces and levy fines in relation to breaches of certain employment obligations. It's likely to cover the minimum wage, statutory sick pay, employment tribunal penalty scheme, labour exploitation and modern slavery, and I think possibly most fundamentally for employers enforcing holiday pay. I think recognising that there's still, despite the change in holiday pay, still lots of employers who haven't maybe adjusted their approach. So we may see soon a new Fair Work Agency that's coming in to ensure the employment rights are being adhered to. Anyone who's dealt with HMRC in a national minimum wage audit will probably know that those kind of processes in terms of inspections and audits of your practices can be incredibly protracted and painful affairs, which are generally seen as being a way to kind of catch you as an employer out. So I'm not sure it's necessarily good news for anybody, but that's what is coming down the tracks.
Thanks, James. I just thought I'd pick up on a couple of the questions that have come through. With regards to, there was a question about unions and access to work places. It will apply irrespective whether you recognise through a statutory process or a voluntary process union. It is a right for the unions to ask for access, irrespective of whether there's any recognition in place. On equality reporting and action plans is something that businesses with over 250 employees are encouraged to do in any event, but it will be a requirement going forward, but it'll only apply to those who are considered to be large employees, i.e. those with over 250 employees. And there was a question about third-party harassment and, what are you going to do with regards to protecting employees from that and what reasonable steps you'll have to take. I think that will come out in the wash a little bit, but it may well be that even with regards to the current obligation to prevent sexual harassment in the workplace, it's something you need to think about as part of your risk assessment. Are you covering off the engagement that your employees have with customers, clients, suppliers, etc., etc.? So I feel like, from the life of Brian, what else have the Romans done for us? So what else has Labour done for us or going to do for us? So as if there wasn't enough, we've already been through, there's going to be a couple of other things that they're also considering. A new right to switch off. They are talking about a new statutory code, kind of in line with what we currently have in Ireland and in Belgium, so that there will be an opportunity for employers to have what they talk about is constructive conversations, whatever that may mean, with their employer to talk about putting in place bespoke policies that would allow them to switch off after work. It will probably take the form of a statutory code, as I said. If that's the case in Ireland, it doesn't create a standalone right for someone to bring a claim under the code, but it will be something that's taken into account in any tribunal or court proceedings. The new Equality, Race and Disparity Bill will look at, again, so large employers 250 plus, will look at introducing ethnicity and disability pay gap reporting. So that will be quite difficult because obviously for lots of employers, although you ask people their ethnicity, etc., and any disabilities, lots of employees don't feel inclined to provide you that information. So in this respect, it might be there'll be some difficulty. I think we're going to wait for the regulations to come out to understand how far-reaching that right and obligation is going to be. But I think it is worth for many employers to start thinking about, how am I going to deal with this right and this obligation? Because I think, when we looked at the implementation of gender pay gap reporting, lots of employers didn't approach that early enough and had real difficulty when it came round to the legislation coming into force. So I would say start looking at this sooner rather than later. As you're aware, kind of in the UK, we have a three-tier system of employment status. We have employees, we have workers, and we have self-employed. The government has indicated that it wants to abolish the separate status of worker, of employee and worker, and move to one single status of just worker. But it's not something, fortunately, that they're going to do straight away. And I think, again, it's one of those ones that's been put in the too difficult box, because everybody agrees that probably some reform is necessary, but no one really knows what that reform is going to look like or how it will work in practice. And then there's going to be further potential changes to the parental and carers leave system. The government is committed to reviewing this because they don't feel that the parental leave system works well for parents. Forget for employers, but works well for parents, which is, I suppose, the primary aspect of it. Conscious that we all have other places to be, and I want to finish on time. I suppose from a takeaway perspective, I mean, one of the first questions we had was, how do we get involved in the consultation process? The government will communicate the consultations that are happening. We will communicate with people the consultations that are happening, and we will seek to ensure that people have the opportunity to engage with those consultation processes. Because it's really important that unless you want the government to do what it said it's going to do, or for the unions to hold, I suppose, the whip hand in this, it's really important that businesses and business organizations engage loudly and comprehensively with the consultation process. That's really important. So we, as I say, keep up to date with our alerts and our blogs, because we will be advertising those in our alerts and blogs. I think the other thing is, just think about, start making an action plan. There will be more regulation. There'll be greater emphasis on enforcement rights. You're going to be looking at 0 hours contracts. You're going to be looking at potentially difficulties in redundancies. You're going to be looking at things like how to change terms and conditions. I think, it's about thinking about now, what do we need to do to upskill our people, to upskill our managers, to ensure we have the right policies in place, to ensure we have the right contracts in place. All of those things. We have kind of almost a 2-year window, subject to the fact we don't know what the regulations are actually going to say, but we almost have a 2-year window before some of these substantive changes are going to take place. I don't know if there's any other questions. I mean, what I would say is that what the government isn't, it's kind of a one-sided process. So they're going to give, it's going to be a greater emphasis on enforcement rights. But at the moment, I mean, anybody involved with tribunal claims knows that in some cases you're not getting hearing dates for 18 months, etc. And there is just a shortage of judges, particularly in the southeast. So cases aren't coming up to be heard, and that creates a real problem. It creates a real problem for employees who think they have a right and therefore they want to challenge that. I think it's also a problem for employers because, as we all know, people move on. So you sit there going, we've got a defense to this claim, and actually the person who's going to be your main witness has moved on. So there were, I think, sorry, I'm just looking through. There were some questions about tips. If you go onto our website, we have an article about the tipping obligations. So hopefully you can look at that. Just looking at some of the questions. Has anybody other questions? Sorry, James, help me out here.
1 second.
On the ethnicity and pay gap reporting, for large employers, that will be as per legal entity. So it will be the same as gender pay gap reporting. So it will be as per each legal entity. So if you've got lots of small legal entities which fall below 250, you should be okay. But any larger ones will fall within that. But again, that will all come out in the regulations.
I think there's a question around third-party harassment. I mean, ultimately, we have to see how this is introduced, or if it's introduced, in terms of kind of identifying how this can be prevented. And it may be in the same way that we're already talking about in the prevention of sexual harassment, undertaking risk assessments, that if that's what you're doing already to think about ensuring compliance with those obligations, that you recommended anyway to think about the entire environment. So what steps might reasonably be taken to prevent harassment occurring from third parties, considering the particularities of the workplace environment.
And there was a question around maternity protection and whether it's enforced now. Yes, it is. It came into force on the 6th of April this year. The same provisions also provide for protection for those returning from adoption leave and shared parental leave. So that hasn't changed, but obviously the government is looking to extend that. So from just redundancy to other forms of protection. So thank you very much for everybody attending. As James mentioned at the beginning, the slides will be available. A recording, if anybody wants to listen to our dulcet tones again, if you have trouble sleeping at night, will be available as well. And we'll also send it out to those people who haven't been able to attend. But if you've got any further questions that have come out from this, then please do feel free to get in touch with either myself or James, and we'll do what we can to help answer the questions. Thank you very much, and enjoy the rest of your day.
Thanks, everybody.